The Senate will come back to order. Secretary Reed, House Bill 439.
House Bill 439 by Representative Zierta of the 152nd and others, a bill to be entitled an act to amend Code Section 48-8-50 of the Official Code of Georgia annotated relating to compensation of dealers for reporting and paying tax and reimbursement deduction so as to revise deductions allowed to dealers, to provide for related matters, to provide for an effective date, to repeal conflicting laws and for other purposes. Mr. President, the Committee of the Senate on Finance recommends that this bill do pass by substitute. Respectfully submitted, Senator Huffstetler, the 52nd District Chairman. Mr. President, the Senate Committee on Finance offers the following substitute to House Bill 439, a bill to be entitled an act to amend Title 36 of the Official Code of Georgia annotated relating to local government so as to authorize the establishment of local homeowners incentive adjustment grant programs, to provide definitions, to provide constitutional authorization, to provide for referendums to establish and discontinue such programs, to provide for the appropriation of funds to support such programs, to provide for the calculation, application, and limitations on tax credits, to provide for rules and regulations, to provide for recoverability, to amend Article 7 of Chapter 5 of Title 48 of the Official Code of Georgia annotated relating to miscellaneous local administrative positions so as to authorize the establishment of local homeowners incentive adjustment grant funds, to provide for an effective date, to provide for related matters, to repeal conflicting laws and for other purposes. Mr. President, that completes the order.
Recognize Senator from the 24th.
Thank you, Mr. President. I bring you House Bill 439. This is a very important bill that we can actually help our property owners reduce their property taxes. This bill authorizes the establishment of local homeowners incentive adjustment grant fund by cities and counties. This too has been available in the state already, but now we want to offer it to the local governments. This bill creates to provide a local community's ability to voluntarily rebate homestead property tax using collected taxes that are determined to be more than their budget requires for that year. Local governments that are experiencing digest growth that does not come along with the additional spending of simply controlling costs so that they have a surplus can use this tool to direct relief to our homeowners. This tool gives local governments a way to provide relief as flexible. The local government decides if it wants to participate. The voters approve the program by a referendum. Then each year, as long as the government has the available funds, the government places funds in an account of its choosing into a separate account, and that account is used to divide the funds between the homeowners. This grant amount will be reduce the homeowner's property tax bill. Thank you so much, and I ask you to vote green on a very important bill for our people that have property owners that have property. Thank you.
You have no questions, Senator?
Thank you. I ask you to vote green
Oh, I'm sorry.
for the great
You do
people of the
have-
great state of Georgia.
You have a question or not, Senator? Or do you? Oh, okay, yeah. You go ahead, Senator. We'll get to them after we get done with the questions. Recognize the Senator from the 51st. Does any other senator want to speak for or against the measure? Chair hears none. Now, Senator from the 33rd, do you want to start excusing for some folks?
Thank you, Mr. President. I ask for unanimous consent to excuse the senator from the 44th for business inside the Capitol.
Without objection, the senator from the 44th is excused. Recognize the senator from the 51st.
Motion to excuse the senator from the 6th for business inside the Capitol.
All right. Without objection, the senator from the 6th is excused. Senator from the 41st.
Thank you. Ask for unanimous consent to excuse the senators from the 44th and the 22nd.
Without objection, the senators from the 44th and 22nd are excused. All right. Is there objection to the previous question be it ordered? Chair hears none. The previous question is ordered. Question is on the adoption of the committee substitute. Is there objection to the adoption of the committee substitute? Hearing none, the committee substitute is adopted. Is there objection to agreeing to the report of committee which is favorable to the passage of the bill? Chair hears none. The report of committee is agreed to. Is there objection to the main question being ordered? Chair hears none. The main question is ordered. Questions on the passage of the bill by substitute. All those in favor vote yea. All opposed nay. Secretary unlock the machine. On the passage of the bill, the yeas are 49, the nays are 1. This bill, having received a requisite constitutional majority, is therefore passed by substitute. Secretary read House Bill 717.
House Bill 717 by Representatives Cooper of the 45th and others, a bill to be entitled an act to amend Article 2 of Chapter 34, Title 43 of the Official Code of Georgia annotated relating to the Medical Practice Act of the State of Georgia so as to provide for the regulation of the administration of psychedelic-assisted treatment and therapy, to provide for definitions, to provide for standards, to provide for requirements, to provide for the establishment of rules and regulations, to provide for licensure of clinics, to provide for statutory construction, to provide for related matters, to repeal conflicting laws for other purposes. Mr. President, the Committee of the Senate on Health and Human Services recommends that this bill do pass by substitute. Respectfully submitted, Senator Watson, the 1st District Chairman. Mr. President, the Senate Committee on Health and Human Services offers the following substitute to House Bill 717, a bill to be entitled an act to amend Article 2 of Chapter 34 of Title 43 of the Official Code of Georgia annotated relating to the Medical Practice Act of the State of Georgia so as to provide for the regulation of the administration of psychedelic-assisted treatment and for other purposes. Mr. President, that completes the order.
Recognize the senator from the 1st.
Thank you, Mr. President. I'm here presenting House Bill 717. Let me first of all say that there are no psychedelic assisted treatment clinics in the state of Georgia. As a matter of fact, there are no psychedelic drugs that are legal in the state of Georgia, or much less the United States of America. There are stage 2 and stage 3 clinical trials going on with psychedelic drugs, and that is why we're here today, sort of a preemptive strike. Because what's happened in the past, and I'll give you an example, the ketamine clinics got ahead of us, and we had to come back in and rein them in. So the Composite Board, Georgia Composite Board of Medical Examiners, or board itself, has been working with other boards around the nation and came to us with this legislation. And this bill, if you'll note, is similar to the ketamine clinic legislation that we passed earlier. So this basically is the bill that, if that ever does become legal, and I will tell you, I have reviewed articles in JAMA and other journals, and it does look like those potential Schedule I drugs would go to a lower schedule and would be beneficial from disorders like generalized anxiety disorder from moderately severe. So that's all this does, is set a framework for the psychedelic assisted treatment clinics, in which it requires certain conditions and rules and all of that. So, Mr. President, I'll be happy to answer any questions on House Bill 717. Thank you.
Recognize the senator from the 14th.
Thank you, Mr. President. I rise in enthusiastic support of this bill, and I just want to note this occasion so that y'all can be aware of how important the work you're about to do is, not just for the people of Georgia in general, but specifically for our veterans and our first responders. We've been talking a little bit in the last couple of years about breakthrough therapies that go beyond traditional pharmaceuticals to try to treat conditions like treatment-resistant depression, post-traumatic stress, and other debilitating conditions that veterans and first responders acquire after their years of service to the local, state, and federal governments. It cannot be stressed enough that some of these breakthrough therapies are so transformational that they don't just treat the symptoms of post-traumatic stress and depression. In many cases, veterans and first responders find after treatment, appropriate treatment, that they are no longer diagnosable with post-traumatic stress and treatment-resistant depression. Really transformative stuff that, because of the federal culture war from several decades ago against these medications, there are veterans and first responders who have left the country to go to other countries where these treatments are more readily available. And so it's just really important for Georgia to recognize the potential for this. Kudos to the senator from the 1st for carrying this, and kudos to the House members who worked on this. But I just want you all to be very proud of yourselves, because this is, in fact, a huge leap forward for Georgia and our ability to respond to the needs of the people who have given the most for us. Thank you, Mr. President.
All right. Thank you, Senator. Senator from the 42nd. For what purpose you rise?
Ask unanimous consent to excuse the senator from the 6th.
He's been excused, Senator.
Well, now he's not.
Oh, never mind. We'll take it now. Apparently he snuck back in here. All right. Any other senator wish to speak for or against the measure? Is there objection for a previous question being ordered? Chair hears none. The previous question is ordered. The question is on the adoption of the committee substitute. Is there objection to the adoption of the committee substitute? Hearing none, the committee substitute is adopted. Is there objection to the agreeing to the report of committee, which is favorable to the passage of the bill? Chair hears none. The report of committee is agreed to. Is there objection to the main question being ordered? Chair hears none. The main question is ordered. The question is on the passage of the bill by substitute. All those in favor will vote yea. All opposed, nay. Secretary, unlock the machine. On the passage of the bill, the yeas are 50 and the nays are 1. This bill, having received the requisite constitutional majority, is therefore passed by substitute. Secretary read House Bill 1020.
House Bill 1020 by Representatives Reeves at the 99th and others, a bill to be entitled an act to amend Chapter 23 of Title 47 of the Official Code of Georgia annotated relating to the Georgia Judicial Retirement System so as to provide for the payment of monthly retirement benefits for creditable service as a district attorney at the age of 65 years, to provide for calculation of benefits for individuals who first become members after the effective date of this act, to provide for calculation of survivors' benefits, to provide for conforming changes, to provide for an effective date, to provide for related matters, to repeal conflicts in laws for other purposes. Mr. President, the Committee of the Senate on Rules recommends that this bill do pass by substitute. Respectfully submitted, Senator Brass, the 6th District Chairman. Mr. President, an auditor's note has been attached. Mr. President, the Senate Committee on Rules offers the following substitute to House Bill 1020, a bill to be entitled an act to amend Article 1 of Chapter 18 of Title 15 of the Official Code of Georgia annotated relating to general provisions regarding prosecuting attorneys so as to modify provisions regarding the compensation received by district attorneys, to provide for procedures for district attorneys to opt to receive compensation pursuant to such revised provisions, to provide for grandfathering of certain district attorneys so as to not reduce the compensation paid to such district attorneys, to authorize locality pay by counties to district attorneys in lieu of county salary supplements, to abolish most county salary supplements provided to district attorneys, to authorize continuation of fringe benefits provided by counties to district attorneys, to preserve existing rights and obligations related to retirement benefits provided by counties to district attorneys, to provide for retirement benefits relative to optional locality pay, to amend Code Section 45-7-4 of the Official Code of Georgia annotated and for other purposes. Mr. President, an auditor's note has been attached.
Mr. President, Senator Hatchett and others offer the First Amendment. Read through district attorneys and auditors.
Mr. President, Senators Hatchett of the 50th District and others offers the following amendment. Amendment 1, amend the Senate Committee on Rules substitute to House Bill 1020 by replacing line 8 with the following: to authorize continuation of fringe benefits provided by counties to district attorneys and for other purposes. Mr. President, an auditor's note has been attached. Mr. President, that completes the order.
Recognize the senator from the 50th.
Thank you, Mr. President. I rise to bring House Bill 1020. This is very similar to the bill we passed last year for the Superior Court judges. This is the same type of idea for district attorneys across the state. There is a just pretty big gap between what the lowest and the highest district attorneys in the state are paid. This allows for parity across the state for district attorneys. It would set a district attorney's salary. The maximum would be 88% of a federal judge, and it also caps the local supplement at 10%, but there is a phase-in. Happy to answer any questions, but would ask for your favorable support. Two questions.
Recognize the senator from the 26th.
Thank you, Mr. President. Gentleman Yield.
I do.
You were mighty brief. Tell us what you are doing with these salaries and local supplements.
We are increasing the salaries that the state pays district attorneys to address the issue of parity across the state for all district attorneys. The district attorney salary will be capped at 88% of a federal judge, which is exactly what we did last year for Superior Court judges. And then the local supplements, we are limiting them to 10% of the amount that the state pays the district attorneys.
Why are you limiting the local supplement? We in those particular districts decide what the supplement is going to be. So why would you come in and limit what we can do?
It goes along the same policy that we have with the judges. And so we're giving the district attorneys a significant bump from state pay to address an issue that we're seeing across the state where some district attorneys are getting paid much less than others, and this is to bring parity across the whole system.
You talk, isn't it true you are talking about different localities with DAs which have more money than the other municipalities or the districts, and so their supplement is higher than those in the other districts? So why would you cap what we do within our districts where we have these judges?
Once again, it's just a policy decision to make parity across the state with district attorneys. If you're worried about a specific district attorney in your district right now, this doesn't require them to opt in. Your district attorney will have the option to either opt in or out. But all district attorneys elected after your district attorney steps down will have to opt in. But the 10% right now would be over $20,000. So we're making your district attorney, if they get the supplement, will make over $200,000.
Will the gentleman further yield?
I will.
You are changing a bunch of it. I tried to read it. I'm not a lawyer. I'm a street lawyer. What you're doing is a significant change in what we have right now. If I'm not mistaken, you change, when new judges come in, you change what we've already been doing as far as our supplement to those judges. Now you are capping them and making the decision for us in the district as to how much we gonna supplement the DA.
I think what we're doing is we're taking the burden of having to finance these district attorneys off the locals, and we're putting it on the state. And so the state will pay the bulk of the salary, and then a local will only be allowed to pay 10% of a supplement, which 10% of a supplement, a district attorney will be making more than a federal judge. That's pretty good.
You still have not answered my question. Why are you trying to cap what we do on a local supplement? Why are you trying to cap what we do within that district and determine from up here as to what that supplement would be?
You know, I've tried to answer it many ways, but I'll try it again. It is a policy decision to bring parity amongst district attorneys. This is widely supported by district attorneys. We are still allowing for a local supplement, but the local supplement will be capped at 10%. That is the most you can give, so that we don't run into this issue again. District attorneys, their caseload, for the most part, is similar across the state. They're elected, and they should have parity.
Recognize the senator from the 36th.
Thank you, Mr. President. Does the senator yield?
I do.
Isn't it true we've heard a lot of language up here in this session about how these metro counties have very special features and have heavy workloads and are at the center of the state and have the largest populations? Haven't we heard a lot of rhetoric about why we need to treat them differently, and in fact have passed a bill that reflects that?
I know we have had those conversations.
That's right. And why wouldn't that reasoning apply here? As the gentleman from Macon was pointing out, those of us in highly populated metropolitan areas who want the best and the brightest in our district attorney's office and positions, and we decide to commit funds to remunerate that position that has an array of complex cases and statistically all sorts of outranking other counties in terms of the demands that are put on that position. Why would it be a smart idea for the state to step in and tell us that we can't compensate our district attorneys in these areas as is the local will, rather than being restricted from that by the state?
I think it goes back to the answer that I gave the gentleman from the 26th. This is a policy discussion, and it's surrounds having parity between all district attorneys in the state, just like we did with the judges. The Prosecuting Attorney Council is in favor of this legislation, and this is something that will bring parity, and it does not do away with local supplements. It allows a local district or circuit to pay their district attorney up to 10% of the state salary.
Further question, if I could. And I'm not picking on anybody's county, but if you compare the workload, the demands, the complexity that a DA in the circuit with Clinch County has with Fulton County, what would that comparison look like?
I think if you just looked at case number, you'd be making a good argument. But
thank you. I appreciate that.
Well, but I will finish. Some counties like mine and other rural counties don't have the resources to have county-funded ADAs, which are assistant district attorneys. They don't have the support staff. So while, yes, larger counties and circuits may have a higher caseload, they also have support staff that is funded by the county. This is for district attorneys only in their elected position, which they run for like we do. We all get paid the same. We get paid the exact same as the House members. It's a government elected position. This is taking a burden off of the locals. And if you're a current district attorney now, you can keep the system you're in.
Further question, if the gentleman will yield. So there's no reason really that you would object to an amendment that removes this cap, this artificial cap that's placed on a locality's ability to enhance the pay for their district attorney. Isn't that right?
I would object. It goes back to the policy discussion that I've been saying since I've been in the well. It's all about parity across the state for district attorneys. And doing that would widen the gap again and would cause an issue where there's not parity between district attorneys.
Well, I think there's considerable grounds for disagreement on that perspective, but I think we've spoken about it extensively at this point. We will all be voting, won't we?
That's right.
Man, Senator, we were moving smooth, and you brought this up today. We got a lot of questions here. Recognize the senator from 55th.
To the gentleman in the well, will the gentleman yield?
Yes, I will.
I think the distinguished senator prior to me has kind of covered where I was going, but is it not true that we just had a bill covering 5 DAs that are in the metropolitan area that was distinctively different than the other DAs in this state?
I'm sorry to my friend from the 55th. I'm not sure which bill you're talking about.
Well, specifically, the real issue that I wanted to address is that we did have legislation that only went to the races, how the elections would be held for 5 metropolitan counties. Is that not true?
Is this, once again, I'm not sure which legislation you're talking about.
Okay.
But if you can let me know, I'm happy to address it.
But is it further true that you just stated that some of your rural DAs don't have the resources that are needed to do their job? Is that not true?
I think what I said is that some counties have more resources than others to pay county-funded positions. And in rural counties, those county-funded positions are not as frequent as you see in the metro counties.
Will the gentleman further yield?
I will yield for one more question to my friend from the 55th.
Well, this issue is so important, and I respectfully understand that you only want to take one more question. But is it not true that those of us who represent the metropolitan area want to get all the resources in South Georgia, because I don't want to drive through your county, someone else's county, and not have competent help? But is it not true that I don't want you limiting what I believe should be in DeKalb County, in Fulton County, in Clayton County, in Cobb County, in Gwinnett County, in any county?
Is that not true?
Well, first off, I'm from North Georgia, but also I think the senator knows
Well,
of what he
even-
speaks
even
and
North
has
Georgia.
his own opinions. With that, Mr. President, I'm happy to yield the will. Thank you.
You have that right. Did you recognize the senator from the 19th?
Thank you, Mr. President. Let's talk a little bit about this. The debate seemed to center around, I think, that this is somehow aimed to hurt metro areas or keeps metro areas from funding their DA's office. That is patently false. What it does prevent you from doing is paying certain salaries of a higher amount to elected officials. It says that if you're an elected official at a certain position, we are going to fix your salary on a statewide scale. That is all this bill says. We have already done that in one other instance. In judges, last year, through the entire judicial branch, we did that. We said if you want to be the title judge, here's what your pay will be statewide. The comment came up that this then prevents metro communities from funding their DA's office. No, it does not. You can fund your ADAs, as many of them as you want. In fact, right now, many metro offices already do. What you can't do is pay an elected official an obscenely large amount or a small amount more than they're getting paid in other areas of the state. When you qualify to run for office, when you put your name on that ballot, when you sign the oath downstairs, you're signing up for public service, not public enrichment. And what this bill ensures is that whatever title you are, wherever you're at in the state, your pay is generally the same. Now, I said generally for a reason, because if you're currently a district attorney, like some people think that this bill is aimed at, you actually have a carve-out here. You get to keep the pay you're making right now for as long as you're district attorney. It is not aimed at you. If it was, we would do what the General Assembly can do and make kind of like an ex post facto law that brought in all the Metro DAs now. But we did not do that. We said instead, if you want to opt into the new system, you can. If you live in Clinch County, like one of our colleagues, the senator from the 36th, brought up, and you want to opt into this new system, then great. If you want to stay under your old system, great. But if you do come under the new system, we are going to make sure if the state's picking up this extra part of retirement, if the state's picking up this extra part of your pay, that the pay has parity across the entire state the exact same way that we did for judges. I want to commend the District Attorney's Council, PAC, for their work on this. I know this isn't universally loved across their board. Neither was the judge pay. But we have seen that a majority of the judges opted into the new system. Some stayed out, as was their prerogative and their right. They also worked with us, PAC worked with us to literally copy the provisions that we put in the judicial bill, noticing that it took us 3 years to get the judge bill worked out. They didn't want to do the same. They wanted to get this done a little bit quicker on their side. So I commend them for their work on this, appreciate what they've done to work with us. It also raises district attorney retirement. You know, district attorneys could retire right now at 60. There ain't nobody in our state retiring at 60 anymore. So we're moving the retirement ages up to make sure these actuarial numbers fit with what we're seeing in the private sector, what hardworking Georgians are doing. They're not retiring at 60. Some aren't retiring at 70. So this puts that job title in a position of parity across the state, and it also puts the retirement in a position of parity as it relates to the folks who are actually paying that wage in the first place. Thank you again to the senator from the 50th for bringing this bill, and I'll yield the well, or I'll take a question from the senator from the 41st, who seems like she wants to ask me one.
I recognize the senator from the 41st.
Thank you, Mr. President. Does the senator yield?
Of course.
Senator, can you talk a bit about the way that Superior Court judges are compensated in terms of, well, not compensated, but just talk to me about their caseload.
Yeah.
Are those caseloads maintained with parity across the state, or is there fluctuation in those?
We try to balance those out across the state. You'll actually see, not to preview what you may see in the later parts of this week, but there's some discussions there on how that caseload system works as well. We don't necessarily need to be creating a system that creates new judgeships every single year.
Sir, do you further yield?
Sure.
So is there a similar system for DAs that allow the appointment of an additional DA when we find that the caseload is becoming more greater than the rest of the people around the state? Is there, a new DA who gets added like we add new judges?
We have split circuits and done things like that before. We're now in the situation, though, where many of the metro circuits are simply one county. And if you read the state constitution, a district attorney's district has to be at least one whole county. So you're barred by the Constitution from splitting that any smaller.
So therefore, is it not true that there are DAs who serve one county who have simply more casework than someone who represents, say, a clinch county?
If you assume that they are trying every single one of their cases, that would be correct. But they are not. In fact, they have many more ADAs than the counties. Like we're picking on our senator from the 8th, buddy, because Clinch County got raised earlier. But the ADAs that are in their county there are more ADAs in those counties too.
Senator, do you further yield?
Sure.
Who supervises all of those ADAs?
Yeah,
Who supervises all of the employees that make that office function?
In the same way that the lieutenant governor supervises every single one of us in the Senate, the attorney general supervises the attorney general supervises his entire office or her entire office. Then the district attorney would supervise their entire office.
Does the senator further yield?
Sure.
You're smooth with your talk, but not necessarily all that accurate.
Well, when you say the same thing, regardless of what room you're in, it sounds smooth, I suppose.
So, Senator, is it not true that each and every one of us in this body is paid a base salary that is the same because we represent the same general amount of people? Is that not true?
We are, but we don't change our pay in year 8 when those numbers are obviously very skewed.
However, do you further yield?
I will.
Is it not true that people who have to commute longer distances get compensated greater because they are commuting longer distances via mileage reimbursements? Is it not true that legislators who have to drive further have greater compensation, that there are opportunities to try to make it more equal? Is that not true?
That is not true. Your per diem is not based on your mileage. Your per diem across district is all the same. Now, your mileage is if you're actually traveling, but we do that for district attorneys too. We reimburse their mileage when they travel. So I think this is an apples and oranges argument. If you want to make the case that an elected official should be paid more money by their county, I'm not falling into that logic. I think that elected officials know what they're walking into. They are paid the same regardless of their title, regardless of their location in the state. And I don't think the public would support it, especially if they realize that a local elected official could be paid 3 times or 4 times or 5 times what an ADA made. How is that fair?
Does the senator further yield for one last question? So earlier you stated that this is a situation where current DAs can either opt in or opt out.
It is.
Is it not true that when a new DA is elected in that same county that still has a greater workload, that has a larger amount of ADAs that have to be supervised, that is working ostensibly more complex cases than another place, is it not true that that person will not have the option to opt out?
Well, I don't accept the premise that they're operating more complex cases. I don't. It doesn't matter how many times the senator from the 36 speaks under her breath. I still do not believe that. So I can't accept that premise. What I can tell you, though, is that an elected official, regardless of where they are located in the state, would be paid the exact same thing based on parity. Remember, the argument that was brought to us first on judges and then on DAs is, hey, there's not parity across this position. We've solved the parity issue. What we're not willing to do is solve the parity issue and leave the parity, or solve the pay issue, leave the parity issue, and then be in this exact same position in 3 or 4 years. Mr. President, if there are no further questions, I'm happy to yield the well.
You can yield the well whenever you like, Senator. Does any other senator wish to speak? There is one. Senator from the 55th.
President, ladies and gentlemen, I really don't even want to dog in this fight, but
I'm all for having justice in North Georgia. I'm for having justice in South Georgia. I'm for justice all over the state of Georgia. But too often we are now picking on Metro Atlanta, and it's getting out of hand. You want to allow the next DA in DeKalb, Gwinnett, et cetera, to be paid what may be an unconstitutional system in the first place. Because I believe that we really need to look at the malapportionment of justice in this state and how we are electing DAs. Because we are from districts that probably do violate the 14th Amendment. And that's a fight that maybe we need to look at so that we can stop playing these other games. Now, with respect to, I represent DeKalb County and Gwinnett counties. I don't represent Fulton County, but I do represent Fulton County because I'm upholding the law of the state of Georgia. And when the Madam DA from Fulton County resigns or goes off somewhere else, we want competent district attorney who will have the audacity to stand up even to the President of the United States and not have somebody who is not paid or compensated well if it matters that democracy is protected. And right now we are again dealing with something as basic as the foundations of democracy, because if you cannot get justice in our courts, which right now the Supreme Court has only 39% approval rating because it's so partisan. And now you're trying to bring that whole thing into the DA's office, into the judiciary system. And I think it's appalling that we would go to this length, because even right now, 61 years after Bloody Sunday, this very month, here we are dealing with this whole notion of who can represent whom. If I want to pay my DA more money, that should be my prerogative. It should be no business of somebody in North Georgia, South Georgia, or no Georgia. Shelby versus Holder took away the Section 5 of the Voting Rights Act, something that started 61 years ago when I didn't have the right to be in here. I want to remind you of that. And right now, there's a case called Calais, Louisiana Calais, threatening Section 2 of the Voting Rights Act. And this body can do whatever it wants to do, it has, whether it's germane or not. But I want to stand and say this wrong. Partisan gerrymandering is wrong. It's destroying this country. When you can draw my predecessor, the woman that was leading the Democratic Party, my predecessor was drawn out of her district, and I'm campaigning in her area and not realizing that's part of why she can't come back. And I think it's wrong when we started attacking each other in the way that we have been doing. It's wrong for Georgia to lead midterm redistricting as it did in 2024, before Texas did, before the Texas legislators left Texas to avoid unfair and partisan gerrymandering. And that's what we're doing here. We are cutting the legs off of democracy chip by chip. And I want you to examine in your heart whether this whole path that we're going down is something that we really want to put above our country. Do we have loyalty to our country or more loyalty to a party? Do we have more loyalty to a country or more loyalty even to an individual? So seldom does it really matter, but I believe it does matter because it needs to be called out as just wrong. It's wrong when I can go to a part of this country, this state, and worry about whether or not I'm going to get justice. I have to say that because some of our jails are filled with people who simply didn't have the finances to get justice. And that's just wrong. And we need DAs that are not there to make a name off the backs of poor people, the least and the lost and the left out, to do what's right. So why do I stand up here today? I stand up here today simply to say that when you are unwilling to do an amendment, and I didn't even draft that amendment, but I asked for some help to draft it, the amendment that just would take off the cap. Because if our county commissioners, if our local elected officials pay a DA too much money, then I believe the electorate, I trust the people. This is the people's house, and I think that's what we forget. We forget that this is the people's house. These are the people that we represent out here. And if they see that DAs are being paid too much, I think they can raise that issue. And I don't think that's the case here. So I think the real issue is we don't have the audacity, the intestinal fortitude to have more than millionaires and retired people in this legislature, in this Senate. Very few people can leave a law practice or a business 4 months and come back and see it. And that's why some of us can enjoy what we're doing here, because we don't have the audacity to pass a bill, to pass legislation to even make 50% of what the governor makes, 25% of what the governor makes, $20,000, because it really doesn't matter. It really doesn't matter. We can't have people, everyday citizens, that can come into this legislature because we've forgotten that this is the people's house. We've forgotten that we can buy elections. Citizens is United is wrong for that reason, because we can now buy elections. And we can be worried about whether someone with money is going to primary you because you didn't vote on one thing. And that's what's wrong with this. We're going down that slippery slope, chipping away at democracy. Now you're going to tell me I can't pay my DA. Not everybody has the audacity to go up against a sitting president, but someone did, and they're paying dearly. The first thing I voted on was dealing with that very issue, and that's this issue still in this legislation. It doesn't say it, but the handwriting is all over it. And I would simply say that I stand here because when someone can say, and I said it about a week or so ago, but when a sitting president can say that the governor of Georgia should be put in jail, if you disagree with the man who recorded that thing that said, give me 11,780 votes, you disagree with the Secretary of State, but to say that because he did that, he should be put in jail. The black woman that was counting, Miss Ruby, that was counting those votes, to say she should be put in jail, I stand because if they can be put in jail, they will put me up under the jail. And that's why I'm standing here, because we need people of integrity, and we need to pay them what they deserve, not the pennies that we come down here and sacrifice. And I want to say thank you for your service. But at the same time, as James Brown said, open up the door, I'll get it for myself. Let's open up the door to democracy to everybody, not just a few. Not just a few, and that's what we're becoming. Thank you for this time. But I say this because I do care about this country. I do care about Georgia. I do care that we would have the audacity to tell local elected officials what they can't do And that's what this bill does. You slip out, you say, okay, if you stay in that position, you can do whatever the local government wants. But once you leave, the next person, we won't pay them. So that's why I stand. And I want to say this because when Section 2 is attacked, this whole notion of what happened 61 years ago when John Lewis got his head blooded, that's a Dred Scott versus, we are in dangerous steps. Whether now you got the executive, you got the legislative, and now the judiciary, you're trying to sew it all up where people are under pressure to do what one or two people want done. And that's why I stand here. I stand here because when we redraw the lines here in Georgia, so that one faction has an unfair advantage over the other, that is not one nation, indivisible. We are dividing rather than having a United States of America. I thank you for listening. I don't have an amendment. I will do an amendment if I have the time that says take off the cap. Senator from the 19th, I respect you very greatly. And the author of this bill, I respect even more. But I would simply say that limiting what local elected officials can do is just wrong. Thank you very much. I yield the well.
Senator is yielded. Senator from 50th, would you like to close? You stirred it up in here, Senator. I don't know if we're talking about a pay raise bill or if we're talking about something else.
Mr. President, I'm kind of in the same situation you are. I did not expect this fight. Didn't think this was going to be as partisan as it turned out to be. I'm just going to make a couple points. The governor's salary was brought up. The number of people you represent was brought up. We're about to pay district attorneys more than the governor. Second, it was brought up about people sitting in our jails. I have a letter from the Georgia Public Defender's Office in support of this. Third, well, this is a metro county. How could you possibly pay district attorneys this in the metro county? This is 88% of the Northern District, which is a federal circuit in Metro Atlanta. 88% of the judge's salary for a federal court in Metro Atlanta. And they can get up to 10% more. So they're going to be making more than the governor. They're going to be making more than a federal judge in Metro Atlanta. I respect the political nature of these debates to some degree. I respect that you've got to, I know you're getting calls from your district attorneys. Let me just say this, call them back and ask them, hey, before you retire, are you going to opt into this system? I guarantee you every single one of them will, because it's fair. With that, Mr. President, I yield the well.
All right. So now it's time, the question is on amendment number 1, authored by the Senator from the 50th. Is there objection to amendment number 1? Without objection, amendment number 1 is adopted. Question is on the adoption of the committee substitute as amended. Is there objection to the adoption of the committee substitute as amended? Hearing none, committee substitute as amended is adopted. Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? Chair hears none. Report of the committee is agreed to. Is there objection to the main question being ordered? Chair hears none. The main question is ordered. The question is on the passage of the bill by substitute. All those in favor of the bill vote yea. Opposed, nay. Secretary, unlock the machine. Senator from the 8th, for what purpose do you rise?
Parliamentary inquiry, Mr. President.
State your inquiry.
Mr. President, is it not true that Clinch County was mentioned quite a few times during that debate?
I believe Clinch County was mentioned more times than I've ever heard it mentioned before in this body.
Is it not true, Mr. President, that down in the flat woods of Georgia, the scales of justice are just as equal in Clinch County as they are in any county in Georgia, Mr. President?
Clinch County is a wonderful, wonderful place, Senator, with wonderful people in it, too. On the passage of the bill, the yeas are 32, the nays are 19. This bill having received requisite constitutional majority is therefore passed by substitute. Secretary Reed, House Bill 1024.
House Bill 1024 by Representatives Hong of the 103rd and others, a bill to be entitled an act to amend Code Section 44-13-100 of the Official Code of Georgia annotated relating to exemptions for purposes of bankruptcy and intestate insolvent estates so as to revise the exemption for a debtor's aggregate interest in real property or personal property that the debtor or a dependent of the debtor uses as a residence in a cooperative that owns property that the debtor or a dependent of the debtor uses as a residence or in a burial plot, to provide for such exemption for the primary residence of spouses, to provide for related matters, to repeal conflicting laws for other purposes. Mr. President, the Committee of the Senate on Banking and Financial Institutions recommend that this bill do pass. Respectfully submitted, Senator Summers, Chairman. Mr. President, that completes the order.
Senator from the 26th, for what purpose do you rise?
Parliamentary inquiry.
State your inquiry.
Is it true, after passing 1020, that I would ask on the next legislative day that the 1020 be reconsidered and given it a favorable majority?
Thank you for serving notice, Senator. And then the appropriate time for it to be reconsidered would be on day 37. Yes, sir, I know. That's a good-looking jacket you got on, too, there, Senator. Recognize Senator from the 16th.
Thank you, Mr. President. HB 1024, this bill increases the homestead exemption in a bankruptcy case. Bankruptcy law is governed by federal law, but some states, including Georgia, have exemptions governed by state law. Exemptions are amounts of assets that you keep after filing bankruptcy in Georgia. The current homestead exemption is $21,500 for an individual, $43,000 for a joint homestead. Our bankruptcy homestead exemption is one of the lowest in the nation. This bill will increase the bankruptcy homestead exemption to $50,000 for an individual, $100,000 for a joint homestead. This hasn't been changed in 11 years. Therefore, it is needed so that we don't forget the updates or the exemptions over the decades for us. This will also, starting in July of 2031, there will be an inflationary index. Also, just as an example of around us, Florida is unlimited, Iowa is unlimited, Kansas is unlimited, and Texas is unlimited. And we are in the bottom half of the last 12 of the states as far as the amount. And I believe this is a good bill in increasing those limits. No question.
Does any other senator wish to speak for or against the measure? Chair hears none. Is there objection to the previous question being ordered? Chair hears none. Previous question is ordered. Is there objection to agreeing to the report of committee which is favorable to the passage of the bill? Report of committee is agreed to. Is there objection to the main question being ordered? Chair hears none. The main question is ordered. All those in favor of the bill vote yea. All opposed, nay. Secretary, unlock the machine. On the passage of the bill, the yeas are 51, the nays are 0. This bill, having received a requisite constitutional majority, is therefore passed. Secretary read House Bill 979.
House Bill 979 by Representatives Bonner of the 73rd and others, a bill to be entitled an act to amend Code Section 50-2-27 of the Official Code of Georgia annotated relating to the retrocession of jurisdiction over lands owned by the United States, so as to provide for procedures for the retrocession of jurisdiction in certain circumstances, to provide for related matters, to repeal conflicting laws, and for other purposes. Mr. President, the Committee of the Senate on Veterans, Military, and Homeland Security recommends that this bill do pass by substitute. Respectfully submitted, Senator Payne, Chairman. Mr. President, the Senate Committee on Veterans, Military, and Homeland Security offers the following substitute to House Bill 979, a bill to be entitled an act to amend Code Section 50-2-27 of the Official Code of Georgia annotated relating to the retrocession of jurisdiction over lands owned by the United States, so as to provide for procedures for the retrocession of jurisdiction in certain circumstances, to provide for applicability, to provide for related matters, to repeal conflicting laws, and for other purposes. Mr. President, Senator Payne of the 54th District and offers the following amendment. Amendment 1, amend the Senate Committee on Veterans, Military, and Homeland Security substitute to House Bill 979 by replacing lines 44 and 45 with the following. The parties, the duties authorized in such reciprocal agreement shall be limited to when alleged acts have been committed by persons under 17 years of age upon United States military installation subject to concurrent jurisdiction. Mr. President, that completes the order.
Recognize Senator from the 54th.
Thank you, Mr. President. My friends, HB 979 is requested legislation from the Pentagon's Office of Military, Community, and Family Policy. This bill provides a framework for our federal military installations to cede jurisdiction to the state in cases that involve juveniles. Federal courts have no juvenile code, so that's what this bill is necessary. Serious juvenile misconduct on military bases and installations are subject to exclusive federal jurisdiction, can only be adjudicated in a federal court system which is designed for adults. States' juvenile courts can adjudicate juvenile cases when concurrent jurisdiction is established between the state and federal authorities, allowing for more appropriate sentencing and case management outcomes for those under 17 years of age. Utilizing only a memorandum of understanding for the referral of cases in areas of exclusive federal jurisdiction, particularly when there is not concurrent jurisdiction, does not create enforceable law, nor is there a legal system for transferring jurisdiction through such means. HB 979 solves these concerns by providing statutory authorization for the state to accept federal relinquishment of juvenile offenses. The broader mission to support children and youth and families remains high priority for the department, clarifying that Georgia authorities may assert jurisdiction over juveniles on military installations in areas exclusive to federal jurisdiction, and enables state law authorities to enforce laws on a base with respect to civilian family members with validity. This legislation is not a mandate It is simply creates a framework for the state of Georgia to accept these cases if desired. HB 979 will help provide a consistent and appropriate legal system for our military families and youth throughout our state. These juvenile offenders are just kids, and they should be treated as such, and that's what this bill simply makes happen. There's also an amendment that I brought forward in this bill because the language of the original bill that came over from the House on line 45 says this code section shall be applicable only to persons under 18 years of age. Well, I'm sure that was written by a federal official and not understanding that in Georgia, those under 17 are juveniles, not those under 18. So that's all the amendment does is clarify that this only applies to those under the age of 17, which would be applicable to juvenile courts. Mr. President, if there's no questions, I will yield the well.
You do have a couple questions, Senator. I recognize the Senator from the 29th.
Thank you, Mr. President. Senator Yield.
I certainly do, from my friend from Columbus.
Senator, is it not true you have experience in the juvenile justice system?
Yes, sir.
And
30 years.
And during that time, did you have to go to court with juvenile offenders?
I had to go to juvenile court several times a week.
Did you ever have to go to court with a juvenile defendant who was a military dependent?
Not where I live. We don't have really military bases up in northwest Georgia, but I'm sure it's very prevalent in where you live, around Fort Benning, Georgia.
I'm just curious, Senator. Is my understanding of the bill that if a juvenile and we'll say Fort Benning, if they commit an act on Fort Benning as a juvenile, that the framework you're trying to build would allow for that individual that case to be adjudicated in the juvenile court there in Muskogee County?
Yes, sir. That's what this bill does.
And if that were to be the case and the parent were to be deployed with family, would that have an impact on that case?
It would have an impact on the case as far as probably the residence of where the court may place them until they've got an appropriate adult to keep them. But it would not as far as their court case. If the parent was deployed, they would still get their day in court in juvenile court.
And if they had already been sentenced to probation or parole, is it not true that there would be an opportunity for that probation and parole to be transferred to another jurisdiction that coincided with where the parent's new deployment would be?
Yes.
Thank you, Mr. Senator. Thank you, Senator. No other questions.
Recognize the Senator from the 15th.
Thank you, Mr. President. Senator Yield.
I am honored, Dean, that you would ask me a question.
Yes, sir. Thank you very much for bringing this bill. Isn't it true that this bill fosters good relationship between the military and the civilian sector, and at the same time have a consideration of children who may infract against the law on military posts and not be caught up in a federal system?
Absolutely. This bill would. Those bridges already exist as where you live, and the military establishments around these areas. Those relationships are already in existence. This really isn't going to create those relationships, but this just codifies it in the law that those relationships are permissive and acceptable.
Thank you for bringing the bill. Thank you.
Thank you.
You have no further questions, Senator.
Thank you, Mr. President. I ask for your favorable consideration and for the amendment. Thank you, Mr. President.
We have a later arriving amendment. Secretary, read the caption.
Senator Tillery of the 19th and others offers the following amendment. Amendment 2, amend House Bill 979 by striking lines 46 through 47 and replacing with the following. Section 2, Title 50 of the Official Code of Georgia annotated relating to state government is amended by adding a new code section to read as follows. 50-18-79. If any claim of an unlawful employment practice made against the General Assembly, the House of Representatives, the Senate, or any member, office, or employee thereof, including but not limited to a claim of sexual harassment, discriminatory harassment, discrimination, discrimination or retaliation is resolved in whole or in part by a settlement agreement, a memorandum of agreement or understanding, or other similar document, however denominated, such agreement shall be subject to public disclosure with the claimant's identity redacted. For purposes of this subsection exclusively, the General Assembly shall be an agency. This subsection shall be applied retroactively. Except as provided for in subsection A of this code section, nothing in this code section shall be construed or applied as to subject the General Assembly to the provisions of code sections 50-80, 18-70 through 50-18-78 or Chapter 14 of this title. Section 3, this act shall become effective upon its approval by the governor or upon its becoming law without such approval. Section 4, all laws and parts of law in conflict with this act are repealed. Mr. President, that completes the order.
Would you like to speak to your amendment, Senator? Recognize Senator from the 19th.
Thank you, Mr. President. Amendment number 2 simply adds what I guess has been termed in our room the Epstein Amendment to Senate Bill 979. Simply says that if the General Assembly has entered into any type of settlement to hide sexual harassment, sexual abuse by members of the General Assembly, that it should be open to it should be subject to open records. The same way that the amendment we passed by Senator from the 29th passed this chamber unanimously earlier this session. Happy to take any questions or yield the well. No questions? Yield the well.
Does any other senator wish to speak for or against the measure? All right. Question is on amendment number 1, authored by the senator from the 54th. Is there objection to amendment number 1? Without objection, amendment number 1 is added. Questions on amendment number 2, authored by the gentleman from the 19th. Is there objection to amendment number 2? Hearing none, amendment number 2 is added. Question is on the adoption of the committee substitute as amended. Is there objection to the adoption of the committee substitute as amended? Hearing none, the committee substitute as amended is adopted. Is there objection to agreeing to the report of committee which is favorable to the passage of the bill? Chair hears none. The report of committee is agreed to. Is there objection to the main question being ordered? Chair hears none. The main question is ordered. Question is on the passage of the bill by substitute. All those in favor of the bill will vote yea. Opposed, nay. Secretary, unlock the machine. On the passage of the bill, the yeas are 50 and the nays are 1. This bill, having received requisite constitutional majority, is therefore passed by substitute. Secretary read House Bill 1164.
House Bill 1164 by Representatives Wade of the 9th and others, a bill to be entitled an act to amend Title 20 of the Official Code of Georgia annotated relating to education so as to require the State Board of Education to appoint an audit committee, to provide for minimum responsibilities of such committee, to amend Chapter 6 of Title 50 of the Official Code of Georgia annotated relating to the Department of Audits and Accounts so as to revise provisions for financial audits of local school systems by and on behalf of the Department of Audits and Accounts, to provide for such audits of state charter schools, to require the Department of Audits and Accounts to develop and implement implement a program of progressive monitoring, supports, and interventions to local school systems and state charter schools, to provide for investigations of local school systems and state charter schools by the state auditor, to provide for an effective date, to provide for related matters, to repeal conflicting laws, and for other purposes. Mr. President, the Committee of the Senate on Education and Youth recommends that this bill do pass. Respectfully submitted, Senator Hickman of the 4th District Chairman. Mr. President, that completes the order.
Recognize the senator from the 52nd. Rome, Georgia's finest. Oh, it's I'm actually from the senator from the 4th. I had a Alzheimer's moment up here. I was just looking forward for the senator from the 52nd so much.
Thank you, Mr. President. It has been a long session. House Bill 1164. This provides additional financial oversight to local school systems. And let me tell you about this bill. House Bill 1164 strengthens financial oversight, transparency, and accountability for local school systems and state charter schools by enhancing audit requirements, creating a fiscal monitoring framework, and increasing state-level review of financial risk in public education. The objectives of this bill is to improve fiscal transparency in K-12 education, to prevent financial mismanagement and deficits, as we know happen in a particular school system in Georgia that's made all kind of news, strengthen audit and monitoring systems, provide early intervention for financially distressed school systems, and protect classroom funding through stronger financial responsibility. In this bill, it requires the State Board of Education to establish a formal audit committee, and that audit committee must meet at least 6 times a year, charged with reviewing fiscal conditions of local school systems and charter systems. This adds a permanent structured oversight mechanism focused specifically on education financing. Each local school system and state charter school must complete an annual financial audit, submit the audit readiness certification by December 31st. This is highlighted. The next few items are extremely important. They must also certify, and that's signed by the superintendent of the school system, the chief financial officer, and the chairman of the local board. They must certify on an annual basis that all state health plan benefits payments are made, and we all know what happened because we heard about this particular school system that missed 14 payments, state health benefit plan. They must certify that all payments have been made timely to the teacher's retirement system. They must certify that public school employees' retirement system payments have been made. They must certify the Department of Labor obligations have been paid. Failure to comply results in high-risk designation. Now, let's talk about the Department of Audits. Will designate school systems as with moderate risk if they have 1 to 2 years of irregularities. If they have 3+ years of irregularities, which is very serious, they will be designated as high risk, and they are required to have a mandatory audit done by the State Department of Audits. State Department of Audits can authorize outside accounting firms to do audits, but if the school system has been designated as a high risk, they have to be done by the State Department of Audits. If financial irregularities or budget deficits are found, school systems must submit a response within 60 days. A corrective action plan must be board approved within 120 days, and monthly expenditure reports must be reviewed and acknowledged by board members while under risk designation. As I stated earlier, there are basically 4 levels of risk. There's Tier 1 is financially sound, Tier 2 is fiscal watch, Tier 3 is fiscal distress, and Tier 4 is critical fiscal emergency. The expanded audit and investigative authority. The bill says that it expands the audit requirements of state charter schools, authorizes investigations into management or misconduct, requires audits in accordance with government auditing standards, allows the state auditor to prioritize audit based on fiscal risk and readiness. As I stated earlier, the state auditor has a tremendous responsibility in this bill, which has not been there in the past. State auditor has discretionary authority to hire public CPA firms, as stated, but all audits must comply with the Georgia Department of Audits. There also is increased transparency. It must require a public notice of financial conditions for any school system that are high-risk systems. It requires posting audit, budgets, financial irregularities online. It expands Office of Student Achievement reporting on financial performance and efficiency. State Board may amend or terminate flexibility contracts if a system is high risk. Charter systems must maintain fiscal stability and corrective plans. And a superintendent, if he's is hired at this point in time, his contract is limited to 12 months. Let me tell you about the positive impacts. Positive impact of this, it protects our taxpayer funds. She ensures responsible use of your tax dollars and my tax dollars. Prevents long-term school system insolvency. Prevents budget deficits. Strengthens early detection of financial mismanagement. Probably most of all, improves confidence in the education funding oversight. Protects classroom funding and teacher resources. This bill becomes effective July 1, 2026. Mr. President, this is a great bill that will protect our schools and protect our students and protect our teachers and will further enhance the use of our taxpayer dollars. I urge everyone to vote green on this bill. Mr. President, I yield the will. Thank you.
Thank you, Senator. Does any other senator wish to speak for or against the measure? Chair hears none. Is there objection for the previous question being ordered? Chair hears none. The previous question is ordered. Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? Chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? Chair hears none. The main question is ordered. The question is on the passage of the bill. All those in favor will vote yea. Opposed, nay. Secretary, unlock the machine. On the passage of the bill, the yeas are 49 and the nays are 2. This bill, having received a requisite constitutional majority, is therefore passed. Secretary Reed, House Bill 1096.
House Bill 1096 by Representatives Taylor of the 173rd and others, a bill to be entitled an act to amend Article 1 of Chapter 2A of Title 31 of the Official Code of Georgia annotated relating to general provisions relative to the Department of Public Health so as to provide that if certain employees of a county board of health become employees of such department, such employees will retain accrued sick, annual, and sick leave, to authorize rules and regulations to provide for related matters, to appeal conflicting laws and for other purposes. Mr. President, the Committee of the Senate on Health and Human Services recommends that this bill do pass. Respectfully submitted, Senator Watson of the 1st District Chairman. Mr. President, that completes the order.
Now I'm ready for the senator from the 52nd.
Thank you, Mr. President. This is a simple cleanup bill for the Department of Public Health where they've had some county employees they're going to reassign as state employees, and if they do, they keep their seniority, they keep their retirement, they keep their accrued leave, but they don't get a payout of the accrued leave. No double bonus on that. That's the bill. If there's no questions, I'll yield the well. And if there are questions, I'll yield the well.
Does any other senator wish to speak for or against the measure? Chair hears none. Is there objection to the previous question being ordered? Chair hears none. The previous question is ordered. Is there objection to agreeing to the report of committee, which is favorable to the passage of the bill? Chair hears none. The report of committee is agreed to. Is there objection to the main question being ordered? Chair hears none. The main question is ordered. Questions on the passage of the bill. All those in favor vote yea. All opposed nay. Secretary, unlock the machine. On the passage of the bill, the yeas are 50 and the nays are 0. This bill, having received a requisite constitutional majority, is therefore passed. Senator from the 31st, what purpose do you rise?
Mr. President, ask unanimous consent to excuse the senator from the 29th for business inside the Capitol.
Without objection, senator is excused. Secretary Reed, H.R. 1416, please.
House Resolution 1416 by Representatives Dickey of the 134th and others, a resolution creating the Joint Study Committee on Generational Sustainability of Family Farms and for other purposes. Mr. President, the Committee of the Senate on Agriculture and Consumer Affairs recommends that this bill do pass. Respectfully submitted, Senator Goodman, Chairman. Mr. President, that completes the order.
Recognize Senator from the 8th.
Thank you, Mr. President. This is House Bill 1416, the same as Senate Resolution 800 that we passed out of here, creating the study committee, the Joint House and Senate Study Committee for the Sustainability of Georgia Family Farms. I got something I want to get off my chest real quick as well, because I came home every Friday. I come home and open up my mailbox, and there's about three mailers in the mailbox from a guy that's running for governor. And I reckon he's got more money than Augustus Caesar, I guess, because, I mean, my mailbox is overflowing with mailers. And I come home, and there's all these things out there that says, oh, you know, talking about politicians, part of a cabal, on the take, that we hold study committee, we have study committees and hold hearings, and nothing ever happens. And this man is going to be all about action. We've had study committees. I was on the Forestry Innovation Study Committee. That helped us figure out that we need to put money in the Georgia Tech program. I've been on study committees that we made changes to CUVA with the senator from the 4th. Just today, we passed a bill on cell phones that came from a study committee. And so I'm not just standing up here for me, but I'm standing up here for all of y'all as well, the hard-working men and women of this General Assembly, that we leave our homes 3 months out of the year and we come up here and we represent our communities. During the time that I've been up here this year, my son's been star student. I missed 2 banquets with that. My mother-in-law's had knee surgery. My father-in-law that I farm with has had his lymph nodes taken out, and they've been there at the farm keeping things going so I could be up here and represent my people. And I reject the notion that I keep seeing out there, not only talking about how I feel it's a reflection on myself, but a character of every member of the General Assembly. So yes, we hold study committee meetings, and yes, we hold hearings. But you want to know why I ran for the legislature? People had tried to get me to run for the legislature, and I never would because I don't have that innate sense of self-confidence like some people do. But it was a trip to Washington, D.C. when they were renegotiating USMCA, and I was asked in there, they said, Mr. Goodman, are you more concerned about trade with Mexico, or are you concerned about trade with Florida and North Carolina? And I was taken aback because this person was representing my family in trade negotiations on behalf of this government. And that is what compelled me to run, because I knew that if this person would ask a question like that farmers needed a greater voice. And that's why I ran. And so I hope that the people of Georgia can see through some of this mess, because it infuriates me, because I see how every one of y'all sacrifice so much to be here and represent your communities. Things are tough on the farm, and I know sometimes in here we can get political about it, but the truth of the matter is things have been tough on the farm for a long time. Georgia farmers experienced about $800 million in profit loss in 2025. Farm production cost has exceeded farm revenue 11 of the past 14 years. That is under Republican and Democratic administrations. Tractor prices have increased 21%. I grew up in the 1980s. I remember when my dad lost a farm to foreclosure. From 1980 to 1990, 1/3 of the family farms in this country were foreclosed on. So yes, we're having a study committee. You want to know why? Because some of the best ideas that we have ever passed in this chamber has come from the everyday Georgians that we represent. But I can tell you, the notion that we're all up here and we're part of a cabal. I'm about to leave here and go home in 2 weeks and try to pick a blueberry crop and hope I can make enough to pay the production loan to Ag South. I'm not a career politician and all this kind of malarkey that you see out there. And so this narrative that's out there with this fellow that seems like he's got more money than, I guess he's got more money than Moses, I don't know. I will say this, though, he is helping the timber industry with the amount of paper that he's been buying, putting these mailers out. But I ask you, and I want to say this, too, in closing, this body in both parties, both metro and rural areas, have always been great about trying to support agriculture. You really have. Why is that? Because we have one common goal. We all like to eat. Isn't that right, Senator from the 14th? And so, with that, Mr. President, I better get out of the well.
Oh, no, you keep talking. You keep talking.
Well,
I like what I hear.
I'm going to tell you, Mr. President, it does upset me when I get home and I see this stuff in my mailbox, because I know how everybody in here sacrifices. We come up here 3 months out of the year, but we know when we're back home in the district, it's a full-time job. And don't get me wrong, it is one of the greatest honors of my life to do this job. Every day that I walk into the Capitol, I wait for somebody to come grab me by the arm and say, "Sir, there's been some mistake. You don't belong here," because I'm just an old farm boy from South Georgia. It truly is an honor. But it is a sacrifice for all of us. And when to go home and see this stuff, it's not fair to any of y'all. It's not fair to the people across the hall, because I know the people in this room, we have profound differences about some things. We have profound disagreements sometimes about things. But I also know that, I respect that you come from a different viewpoint. You have different life experiences, and that is part of the great mosaic that makes the fabric of the state of Georgia and this country. And I respect that. But I also know that by and large, the majority of the people that I serve with are men and women of integrity who truly want to make their mark in their communities and represent their folks back home. So I'm going to hush with that, Mr. President. But if y'all will support this bill, and I hope coming out of this study committee that we're going to find some real solutions. There's only so much we can do on the federal level. There's so much that is outside the control of the American farmer. But I know that we've got to do the work to find out. Mr. President, it wasn't just too long ago that we passed a law that passed out unanimously in this chamber with Austin's Law. That came from a constituent. The senator from the 16th had a bill in committee not too long ago that came from another constituent. And I'll go ahead and say I broke down and started crying in the committee because it reminded me so much of what happened with my son. But the work we do up here, it does matter. And one of the reasons that with these study committees is it puts us in front of our constituents because we are here 3 months out of the year. And when we are off, we do have to do the work that it takes to find the solutions that we can do. That's what a study committee is, right? I'm proud to serve with y'all. God bless you. And to the people watching, don't believe any of that mess you're seeing in your mailbox. Mr. President, I yield well.
All right, Senator. Senator is passionate about agriculture business. I love it. Any other senator wish to speak for or against the measure? Chair hears none. Is there objection to the previous question being ordered? Chair hears none. The previous question is ordered. Is there objection to agreeing to the report of the committee, which is favorable to the adoption of the resolution? Chair hears none, and the report of the committee is agreed to. Is there objection to the main question being ordered? Chair hears none. The main question is ordered. The question is on the adoption of the resolution. All those in favor of the resolution will vote yea. All opposed, nay. Secretary will unlock the machine. On the adoption of resolution, the yeas are 52, the nays are 0. This resolution received the requisite constitutional majority is therefore adopted. Senator from the 41st. We're doing some special actions too, real quick, guys, girls.
Mr. President, I move that the Senate agree to the House substitute to SB 350.
Secretary, read the caption.
Senate Bill 350 by Senator Jackson of the 41st and others, a bill to be entitled an act to amend an act providing for the compensation of certain county officers and officials of DeKalb County, approved March 31st, 1976, as amended so as to revise the compensation of certain judges, judicial officers, and county officers, to make conforming changes related to court names changed by general law, to provide for related matters, to provide for effective dates, to repeal conflicting laws, and for other purposes. Mr. President, the House offers the following substitute to Senate Bill 350, a bill to be entitled an act to amend an act providing for compensation of certain county officers and officials of DeKalb County, approved March 31st, 1976, as amended so as to make revise the compensation of certain judges, judicial officers, and county officers, to make conforming changes related to court names changed by general law, to provide for related matters, to repeal conflicting laws, and for other purposes. Mr. President, that completes the order.
Recognize the senator from the 41st.
Thank you, Mr. President. I rise to ask that you all just bear with me for a moment here. This is a local bill. It was on our local consent calendar. However, due to a drafting error on this side, it had to go to the House, and all special actions have to be presented like this. You can't put them back on the local calendar. So that's how we find ourselves in this posture, is because I need just an outright agree. Just for the underlying bill, what it does is it changes the circuit from Stone Mountain Circuit to DeKalb Circuit. And then, as you will recall from our earlier conversations today, we passed a bill together in this body that set pay for Superior Court judges. And that bill actually derailed the train that DeKalb County has as it relates to compensation. And so this bill allows us to set our salaries once more again for all of our elected officials. I'll stand for questions.
You do have one question, Senator. Recognize the senator from the 19th.
Thank you, Mr. President. Senator, you yield?
I'm happy to yield to the Appropriations Chair.
Senator, I point you to line 30, the district attorney pay. Is that not literally in direct contradiction to the general bill we just passed 20 minutes ago?
Well, we passed this bill several weeks ago out of this body, this bill, so we could not have projected and imagined the mind of what will come today ahead of time. So what this says again, it just resets this is a long-standing tradition in DeKalb County. We're not doing anything behind the door, something we haven't always done. Our DHA has always been at 100%, or has been at 100% for quite some time. So if it contradicts your current bill, that's not on purpose. We introduced this a long time ago.
Will the senator further yield?
I'm happy to yield.
So this was a piece of local legislation originally.
That's right. It's a local bill.
So in the discussions that we had with the Supreme Court when we were drafting the Superior Court's bill, they told us that local legislation would be subservient to general legislation, but the issue had never been tried. Do you have an opinion on if we pass this bill, as you've got it right here, on Special Action Senate Bill 350, would that take precedent for the DA pay for DeKalb County over the bill that this body just passed? Again, it might have been more than 20 minutes ago now.
Well, Senator, I appreciate your question. I'm not a lawyer. I certainly can speak like one sometimes, but I'm not a lawyer, so I don't want to speak to that issue. What I can say is that because of the opt-in provision in your bill, actually was the senator from the 50th bill, because of the opt-in or the opt-out provision, it is our understanding that our DA will opt out because she's at 100%, and so we will not be derailed by this general bill. However, when we elect a new DA, many years from now, hopefully, then I suspect that this body will have to come back and make some adjustments. But for the time being, we are in a good posture to move forward.
Will the senator yield for, I guess, I want to understand how that would put us in the position to move forward if your district attorney's bill, the pay for your district attorney would now supersede the bill we just passed setting district attorney pay differently.
To be clear, we are not giving our district attorney a raise. This is reestablishing, because last year's bill made essentially all trains that were tied to Superior Court judges, it froze them. So we are in a posture of having to recreate our train once more. Our state court judges are receiving a pay that is well earned and absolutely necessary, but we're not actually giving our DA a raise. So it's not in contradictory. She will stay where she is. And again, until there is a new election for a new DA, that's when I will probably be coming back to this body, should I still be here, to need some adjustments to our local bill. But this is actually quite fine as it is.
Can I ask you one more time? I don't understand how this wouldn't give your district attorney a raise in contradiction to what we just passed. If it's 100% of the Superior Court judge, and we were to raise the Superior Court judge's pay last year, you're saying your district attorney was already making 100% of the Superior Court judge's pay last year?
That's correct.
So the pay for your district attorney is what?
I actually don't know offhand because she has a local supplement, right? But our DA is compensated appropriately for the caseload that she has. I will say on behalf of the entire Senate delegation from DeKalb County that we are proud to be able to compensate our DA fairly and adequately. This bill fundamentally is actually not about the DA. It's about reestablishing our train and also making sure that our state court judges are adequately compensated. So that's what this bill does. We are not trying to derail or undermine anything as it relates to DA pay. With that, I'll yield the well.
Does any of the senators yield? Does any other senator wish to speak for or against the measure? All right. So it is a motion on SB 350. And the motion is the senator move to agree to the House substitute on SB 350. Senator from the 19th, for what purpose you rise? It's up to you. We're really kind of down to an up or down vote here. So the motion that was made that the Senate agree to the House substitute on SB 350. Senator has spoken to it. Senator from the 42nd, for what purpose you rise?
Mr. President, I move the Senate agree to the House substitute to Senate Bill 350 as amended by Amendment 1.
Secretary, read the amendment.
Mr. President, Senator Strickland of the 42nd and others offers the following amendment to Senate Bill 350, Amendment 1, by striking line 30. Mr. President, that completes the order.
So, Senator from the 42nd, would you like to speak to your amendment?
Thank you, Mr. President. So the issue we have is we create some inconsistency here with the local legislation versus a bill that passed earlier. So what the amendment would do would just strike line 30 to remove that percentage completely, and then we can let the underlying bill, if it passes, that'll now govern the salary of the district attorney for the Stone Mountain Circuit. Happy to take any questions.
Recognize Senator from the 14th.
Thank you, Mr. President. Does the senator yield?
Yes.
So by striking line 30, I see the lines 29 and 31 will remain in text. So is the intent of the author of the amendment to go from 1 chief executive officer to 3 sheriff immediately with no intervening number? Is that the intent?
No, the intent is to try to make sure we don't create contradicting legislation with the local act versus the bill we just passed. So all that we're trying to do is pause and take this out so we don't create inconsistency, but also make sure we don't kill the underlying bill, to make sure that a DeKalb delegation can still set their salaries as they want. And this is a way to hopefully put a pause on that one part based on the inconsistency we may be creating.
Senator, further yield?
Yes.
Senator, is it not true that the bill that we passed earlier today will still have to go to the House for consideration? So would it not be the most prudent course of conduct and most in line with all of the discussions that have been happening around DeKalb County to go ahead and pass this bill and let the House decide later in time how they would like to handle the issue? Wouldn't that be the most prudent course, Senator?
No, I think the most prudent course, what I was trying to advocate for, was holding on this bill completely right now. That way we can see what goes on with the other bill, make sure we pass something that's consistent. That was what I think is the most prudent thing. But if we can't do that, I think we have to pass the amendment.
Thank you, Senator.
Recognize Senator from the 41st.
Mr. President, I would like to ask that this bill be tabled.
So probably need to start with your motion to agree first. Withdraw it.
Mr. President, I will withdraw my motion to agree to the House substitute. And I'm asking for unanimous consent to withdraw.
Thank you, Senator. Senator from the 42nd.
I move that I'll actually withdraw the motion that I made to agree to the House substitute as amended by Amendment 1.
Is there objection? Hearing none.
Mr. President, I move that we table SB 350.
Is there objection? Recognize Senator from the 41st.
Thank you, Mr. President. I withdraw my motion to table and just ask that we leave it in its posture of availability for special action.
Okay. Thank you, Senator. Tell you what, you get a bunch of lawyers involved, they'd mess up a one-car funeral procession. Recognize the senator from the 1st.
Thank you, Mr. President. I move that the Senate agree to the House substitute to SB 427.
Secretary, read the caption.
Senate Bill 427, represented by Senators Watson of the 1st and others, a bill to be entitled an act to amend Article 2 of Chapter 34 of Title 43 of the Official Code of Georgia annotated relating to medical practice relative to physicians so as to provide for limited provisional licenses and a pathway to licensure for certain internationally trained physicians, to provide for definitions, to provide for qualifications and conditions, to provide for penalties, license sanctions, and enforcement, to provide for one or more medical directors, to provide for annual reports, to provide for rules, regulations, and procedures, to provide for conditional automatic repeal, to provide for related matters, to provide for a contingent effective date, to repeal conflicting laws, and for other purposes. Mr. President, the House offers the following substitute to Senate Bill 427, a bill to be entitled an act to amend Article 2 of Chapter 34 of Title 43 of the Official Code of Georgia annotated relating to medical practice relative to physicians so as to provide for limited provisional licenses and a pathway to licensure for certainly internationally trained physicians, to provide for definitions, to provide for qualifications and conditions, to provide for penalties, license sanctions, and enforcement, to provide for one or more medical directors, to provide for annual reports, to provide for rules, regulations, and procedures, to provide for conditional automatic repeal, to provide for related matters, to provide for a contingent effective date, to repeal conflicting laws, and for other purposes. Mr. President, that completes the order.
Recognize the senator from the 1st.
Thank you, Mr. President. This may be the simplest thing we do all day. So if you go to the original bill on line 107, 427, it reads, shall be fined not more than $500 for each, and it goes blank. And then they picked that up in the House, and so we just added the word offense in the House. So it shall be fined not more than $500 for each offense. Both lines 107, we just left off the word offense. They put it in the House, and that is the only difference in this internationally trained physician legislation that passed both houses overwhelmingly. I'll be happy to answer any questions, but I think that's pretty straightforward.
Yeah, no questions, Senator. Anybody like to speak for or against it? Hearing none. Is The senator has moved that the Senate agree to the House substitute on SB 427. Is there objection? All those in favor will vote yea. All opposed, nay. Secretary, unlock the machine. On the motion to agree, the yeas are 46, the nays are 4, and this motion has prevailed. Recognize the majority leader for a motion.
Mr. President, I move the Senate stand adjourned pursuant to H.R. 998 till 10 a.m. March 25th.
Majority leader has moved. Secretary, read the announcements.
The Rules Committee will meet upon adjournment in room 450 of the Capitol. The Public Safety Committee will meet at 3:30 p.m. in room 450 of the Capitol. The Health and Human Services Committee will meet at 4:30 p.m. in room 450 of the Capitol. The Finance Committee will meet at 5:30 p.m. in room Mezzanine 1. The Judiciary Committee will meet at 6:30 p.m. in room 307 of the CLOB. Mr. President, that completes the order.
All right. Any other announcements? No other announcements? All right, the majority leader has moved that the Senate stand adjourned until 10 a.m. Wednesday morning, March 25th. All those in favor signify by saying aye. All those opposed, no. Ayes clearly have it. Y'all have a good evening.